Welcome back to Protecting and Preserving Wealth. I'm John Jack Gay, joined as always by Bruce Hosler, Jason Hosler, and Alex Corey of Hosler Wealth Management. Always good to be with you guys.
Great to be with you guys this morning.
Hey there, John.
John, how are you today, my friend?
I'm good, and today we are talking about a very important topic, and not because it's complicated, but because it's often overlooked. Most families believe they've handled their estate planning. They've checked the box. There's a will somewhere. Maybe a child was added as a joint owner to an account for convenience. But most of the time we find estate planning is something that people know they need to do, but they've never really gotten around to it or even updated it. So today we're going to walk through a real-life scenario the team recently encountered, one that highlights how good intentions, without proper planning, can lead to unintended legal, tax, and family unity consequences. Alex, you want to sort of set the stage for us here?
Absolutely, John. So we've been working with a client for a few years now that we knew her mother has dementia or had dementia. She lived out of state all the way across the country, and her siblings were helping take care of the mother, of course. And recently the mother passed away. Well, comes to find out that legally she died without a will. She died intestate, and there was no trust plan either. One of their largest assets that the mother owned was a brokerage account that was in joint tenancy with one of the siblings.
So just to reiterate there, one of the biggest assets was a brokerage account that your client's mom owned with one of her siblings.
That's correct.
It became jointly with the sibling because she put it into a joint account with the siblings, or with the sibling, excuse me. And we're not sure of all the details of who was advising them or advising the mother to set it up that way. But the brokerage account was held in joint tenants with rights of survivorship between the mother and the oldest sibling who lived close by. And I'm sure they had good intentions, and they were trying to avoid probate.
So what happened next?
Well, because the account was held in joint tenancy, that means when the mom passed away, the other owner, the sibling, that account automatically becomes the sole property of that oldest sister who was on the account.
Yeah, and the problem with that is that the other siblings were technically disinherited from this estate, from the joint tenant account, and probably other assets as well. Simply put, by just having the brokerage account in the name of one of the siblings and the mother automatically excludes the other two siblings from being a potential inheritor of those assets, even though that may not have been the intent of the type of estate plan that they thought was in the best interest of everyone.
So the unintended consequence, that's what happens when there's not proper advice, is even though the oldest sibling now wants to distribute the assets fairly with her other siblings, there's no legal obligation for her to do that. Mm-hmm. Additionally, because the amount of money involved, if the older sister now gives the correct shares of the funds, of the investment, of the stock to each of the siblings, as was her mother's wishes, she's likely going to have to pay a tax professional to file a gift tax return, a 709, for each of her siblings to use a portion of her lifetime exemption amount, perhaps to the detriment of her own family and her own children. And certainly this can potentially create tension between her siblings and resentment and potentially a long-term family conflict.
Bruce, you made a really good point at the end there, because I was thinking about the dynamic of the siblings, of course, at this point, because you've got, one person has everything and, who wants what does she intend to do? But you're right, that lifetime gift tax exemption, if she's trying to, dole this out fairly, that was going to eat away at that lifetime exemption and could hurt her down the road for her potential inheritors if she has kids or things like that. That's a great point.
Absolutely. And then had the investments simply been held in a trust, or even if they had just left them in an individual brokerage account, the assets in the trust or the account would have received a full step up in basis, in cost basis, when mother died, potentially leaving the entire account balance as a tax-free inheritance to her children. This is the big shame.
We were getting to the tax implications now. Forget the family thing. The tax part is huge, as you just mentioned, Bruce.
And here's the issue with all this. So the original shares that were held in this account were purchased at a price of about $10 per share. And now currently in the marketplace, those are worth $1,000 per share. And there's about 10,000 shares in total in this account. So because of the way that the estate was set up with a joint tenancy, with one of the siblings being the surviving tenant, only 5,000 shares receive a step up in cost basis. So the 5,000 shares go from $10 to $1,000 per share. All right. Now, if the sibling or the sister gifts the shares to her siblings, they're going to receive low basis stock more than likely, as well as a tax bill associated with selling those shares as a capital gain, as opposed to getting a full step up in the total cost of all the shares. So no one had to pay any capital gains taxes.
I want to make sure I'm doing the math right on this before I turn to you, Jason. So we said $10 a share, now $1,000 a share, 1,000 per share times 10,000 shares is $10 million, and you only get the step up basis on half of that?
That's right, just on half. So those other 5,000 shares with the $10 basis, that's $5 million of unrealized capital gains. And at a 20% capital gains rate, that's $1 million tax bill that could have been avoided simply by having the correct account titling and paying attention to these types of estate planning questions and avoidable mistakes ahead of time.
So it was too late to prepare for this particular family that you're talking about, but let's talk about what they could have done prior, and hopefully that can help save some of our listeners.
All they had to do was leave the account in mother's name or create a revocable living trust and set the account in a revocable living trust. Either one of those would have avoided this problem. And the other thing that I want to make sure for our listeners is very clear here is when the sibling gifts those shares to her siblings, her cost basis is only $10 a share. That cost basis goes to their sibling receiving that gift, and they maintain that same cost basis of only $10. They don't get to step up, and that's what creates the big taxable event. That could have been avoided and could have been zero taxes, a full step up in basis on all 10 million. Now, good estate planning importantly involves proper account titling and holding the right type of assets in the right type of account with proper coordination between the assets, whether it's real estate or brokerage or IRAs. And it's not just about having your legal estate documents prepared. Good estate planning does require you to have the necessary legal documents so you don't end up with a result like what we see here.
That's right. I know a lot of folks see and think of estate planning as being a very expensive process because you're thinking attorneys get involved and we have to pay all these extra fees and it's the hourly cost, so forth and so on. But in this example, we can see how large the cost is, which is $1 million of capital gains potentially in the future.
No, that's actual taxes, Alex. That's not the capital gains. That is the tax itself. $1 million of tax.
That's right. Sorry, exactly, Bruce. Thank you for clarifying that.
We're talking some pretty big numbers here. It's pretty easy to get him confused. I'm glad we clarified that.
They are. And all that really had to happen is, especially when the family knew of the condition of the mother in this case, of being able to sit down together before this event occurred of her actual death, is just reviewing the current estate planning documents with a trusted advisor, someone that can at least give you the review of the overhead of all the nuances of what goes into those documents regarding asset titling, beneficiary designations. Again, getting that view to know what's actually going to happen should this event or when this event occurs, when the death occurs. And then from there, proper steps could have been taken to avoid this very costly situation. And that's why we're sharing with our clients today, because we don't want people to have these situations, obviously. We help our clients with complimentary estate planning reviews of their trust and estate documents to catch those errors that can be very, very costly.
And just think about the conflict that this family might face now. You know, you've got half of those shares that don't get a step up in basis, and you're going to have a decision made about, are those the shares that get gifted? Is it the sister that's on the account that keeps those shares? How do you split that up? You're creating a lot of potential for tension and conflict by not having this done ahead of time.
And I want to underscore here that we're not singling out this particular family, because this is really a common problem. And we see this, I'm sure, every day in the industry. Bruce, I know you've got some statistics about how widespread this issue is in the country.
Well, yes, let's just bring this to the forefront. 60% of Americans have no estate plan. That means no will, no trust, no powers of attorney, no documents for their estate planning at all. And nearly 70% of estate plans are outdated. And, you know, we just went to a conference last week, Jason and Alex and I, on this. And one of the things that kind of came out of there that kind of caught me off guard. Now, my estate plan, my trust was prepared in 2017. And one of the things that came out of the conference was, hey, if your trust was prepared before 2019, you probably don't have digital asset language in your trust or your will or your powers of attorney. That has all come to the forefront in legal documents in 2019 and later. So my trust was prepared in 2017. I need to update my stuff. And this applies to a lot of our clients. We need to be reviewing your documents and making sure that you have it. And now people will say, well, I don't have any cryptocurrency. No, digital assets involves, what about access to your iPhone and all of your pictures on your Facebook account or all the pictures in your iPhone account? There is all kinds of digital assets that all of us have, and we need to have the access to that.
Something I see working full-time in podcasting is the law does not always keep up with the technology. So that's a really good point, Bruce, that's something that if you have the if you're in the minority and you've established your estate plan a while back, you really need to take a look at that and make sure this modern piece of it is considered.
Right, absolutely. And this is just one case. I mean, there's other tax law and other implications that are being updated all the time.
That's right. So it's not just a one and done event like most people want to believe. It has to, go through a process of updating every few years, like Bruce had mentioned, because families change, dynamics change, and laws change.
A short review today, folks, can prevent years of conflict in your family. If you love them, please do this.
It's not about perfection. It's about clarity. And, you talk about updating this. I know psychologically when I've got my to-do list every morning, I like to check stuff off. Okay, that's done, that's done, that's done. I feel like a lot of people do that with estate planning. But as you mentioned, it's a living plan. You need to adjust it as life and needs change. So, gentlemen, if somebody wants to contact you at Hosler Wealth Management regarding estate planning or anything really related to their financial future, what are the best ways to reach you?
Certainly, they can reach us on the website, john@hoslerwm.com. In Prescott, they can call us at what number, Jason?
Give us a call at 928-778-7666.
And Alex in Scottsdale, how do they get us down there?
480-994-7342.
Really important stuff, gentlemen. I'm glad we covered this today. Again, not because it's complicated, but because a lot of people have not done this. We'll talk again in a couple weeks.
Thank you, John.
Investment advisory services are offered through Mutual Advisors, LLC, DBA Hosler Wealth Management, an SEC-registered investment advisor. Securities are offered through Mutual Securities, Inc., member FINRA SIPC. Mutual Advisors, LLC, and Mutual Securities, Inc., collectively Mutual Group, are affiliated companies. Forward-looking commentary should not be misconstrued as investment or financial advice. The advisor associated with this podcast is not monitored for comments, and any comments should be given directly to the office at the contact information specified. Any tax advice contained in this communication, including any attachments, is not intended or written to be used and cannot be used for the purpose of 1. Avoiding federal or state tax penalties, 2. Promoting, marketing, or recommending to another party any transaction or matter addressed herein, and 3. Tax preparation and accounting services are offered independently through Hosler Wealth Management Tax Services. Any tax advice provided by tax professionals under Hosler Wealth Management Tax Services is separate and unrelated to any advisory or security services offered through Mutual Group. The accuracy, completeness, and timeliness of the information contained in this podcast cannot be guaranteed. Mutual Group does not provide tax or legal advice. You should consult a legal or tax professional regarding your individual situation. Accordingly, Hosler Wealth Management does not warranty, guarantee, or make any representations or assume any liability with regard to financial results based on the use of the information in this podcast.